Predatory bidding occurs when a buyer bids up a resource's price so high that the competition can't afford to compete and is forced out of business. As a result, the buyer gains monopsony power and dominates the market. In Weyerhaeuser Company versus Ross-Simmons Hardwood Lumber Company, the United States Supreme Court considered the applicable standard for evaluating predatory bidding claims. Weyerhaeuser Company operated sawmills and sold hardwood lumber. In 1980, Weyerhaeuser entered the Pacific Northwest market, and from 1990 to 2000, it invested millions of dollars into its operations. Due to the investments and increased production technology, Weyerhaeuser's demand for logs increased. By 2001, Weyerhaeuser was purchasing approximately 65% of the region's logs. Ross-Simmons Hardwood Lumber Company operated a mill in Washington and was one of Weyerhaeuser's competitors in the bidding market for hardwood logs. From 1998 to 2001, the cost of logs increased, while the price of the finished product, hardwood lumber, decreased. Due to these divergent trends, Ross-Simmons suffered significant losses. By 2001, Ross-Simmons was out of business. Ross-Simmons brought an antitrust suit against Weyerhaeuser, alleging that Weyerhaeuser had unlawfully engaged in predatory bidding by bidding up the price of logs and forcing Ross-Simmons out of business. Weyerhaeuser argued that Ross-Simmons hadn't satisfied the standard set forth in Brook Group versus Brown and Williamson Tobacco Corporation. Ross-Simmons admitted that the Brook Group requirements weren't met. However, the district court rejected Weyerhaeuser's argument, finding that the Brook Group standard only applied to predatory pricing claims and not predatory bidding claims. The jury found for Ross-Simmons. The Ninth Circuit affirmed. The United States Supreme Court granted cert.